feel free to ask in Farsi. I can understand, but my spoken is not yet. Okay. So we've been asked to give a short presentation on will. Sorry, my laptop stopped working, so I have to go to my phone. I've given one before. I don't know obviously how many people have seen it before, but it's about wills in England and Wales. Which is very, very different, obviously, from the Islamic perspective. So this is only the legal perspective I'm going to be talking about today. And what happens in the UK is that a lot of people sometimes die without a legal will in place. Now, again, Islamic wills have different, very different conditions to the English wills, the English legal wills. So what happens here, if someone, God forbid, dies without a valid will, it's the government, the law, which states how the person's estate is basically distributed. Okay, so the person doesn't have a choice. So obviously, in Islamic law, we have a system whereby that if a person dies, it will go to the wife, it goes to two share will go to the son, the one share will go to the daughter. But in English law, that doesn't work. And what happens is that the law will decide how that person's estate will be distributed. Okay, so at the moment, if a person has an estate more than £270,000, what happens is that if the person is legally married, that share of that person will go to their spouse, to their husband or their wife, the first 270,000. The remainder will be split between any children that person has and their spouse, and that will be half. Okay, so the first 270,000 will go to the wife or the husband, and then the rest will be split in half between the. Do you have to? Oh, you don't have slides. No. Okay. So I did have slides, but you don't have a. They can't see that yet. There were slides, but there's no screen, unfortunately. Okay. So it will be split between the children and the spouse, and again, which is very, very different, as you can see, to Islamic law. So it's very different to how that works out. All right. So why we stress to have a legal valid will is to make sure that the Islamic component is adhered to, as well as obviously your wishes, because it will be the law that stipulates how your assets are distributed. All right. For example, I'm going to give you an example. So if Adam and Maryam are married and they have a total estate worth £300,000, and Adam passes away without a will in this country, what happens is that the first 270,000 will go to his wife. Okay, out of that 300,000, the 30,000 remaining will be split in half between the wife. So, and again, 15 will go to the wife, and and then the rest will be split equally between the children. So if he has 2 children, it will be 15,000 each. And as you can see, there's a big difference between what Islamic law would say and what English law would say. Okay, so the importance of having a will would be to set down your wishes as in accordance to what you would want to be given out. All right. Now, again, this is going to be a very, very quick recap. Obviously, it's not very comprehensive at all. The will, the testator, has to be over 18 years old, has to be of sound mind. So the second that, God forbid, anyone has mental capacity issues, so dementia, any form of dementia, Alzheimer's, anything like that, they are no longer able to make a will. That's it. It stops. Their time stops for them. All right. So if they've made a will, then that will be valid once they pass away. The will must be in writing, so we don't have oral wills unless it's very specific, exclusions. You have to have your full name, your address. You have to appoint a executor, which is the person who will carry out your wishes after you pass away. Okay. You have to sign the will in front of 2 witnesses who have to sign in front of you. So all 3 of you have to sign in front of each other. Okay, and those 2 witnesses must not be related to you and must be adults over 18 and must not be taking any gift under your will. If they do, the gift to them fails. So, for example, if I give, if I've left £1,000 in my will to Mrs. Mehdi, for example, and Mrs. Mehdi witnesses my will, then she won't get that benefit of that gift. Okay, so you have to be very careful. All right. Now, the main thing that obviously in this country is inheritance tax regarding will. And as we all go to work, or if we sell homes, we are subject to different types of taxes. So when we buy a property, it's stamped. When we rent a property, we have to pay income tax. When we sell, it's capital gains tax. When we die, it's inheritance tax. All right, so everything is taxed from life to death. Inheritance tax in this country is very, very high. It's 40%. Anything over £325,000 of your estate. All right, and when we say estate, it means everything that you own. Your house, your stock, your shares, your bank account, anything that you own will be totaled up. And if your assets, anything that you own becomes more than 325,000, then it's subject to inheritance tax at 40%. All right, and that again has to be payable by executors when you pass away. There are some new extra additions for the inheritance tax. So it's a relief, it's called, and it's called the residence nil rate bound. So basically it means that if I leave my own home, the home that I live in, not my rental home, not my investment home, not my bank's account or anything like that, just the home that I've lived in, then I can add an additional 175,000 as a nil rate band. Okay, so then I have a 325,000 plus the 175,000 to reduce my potential inheritance tax liability. Okay, but again, that's only for the home that I live in. It doesn't attach to, again, like I said, my rental property or my bank account or anything like that. Now, husbands and wives, they can legally married, not Islamically married. So if you're legally married in this country, or if you're legally married abroad, anywhere in the world, as long as it's a legal marriage, you will be regarded as a legal spouse in this country. If you're legally married, you can pass your tax, your inheritance tax threshold to your husband or your wife. All right. So for example, if a husband and a wife own a home together, and the wife passes away first, and then she gifts, or they own it jointly and go straight to her husband. So the wife has not used her tax band, because the tax between a husband and wife, there's no tax between a husband and wife. Okay, so once the wife has passed away, the husband now owns the house outright. So he can now use his own tax band and his wife's tax band on his passing away. So he now potentially has 650,000 tax-free to pass to his children or whoever he wants to. Okay, now if he wants to pass the house to his lineal descendants, so his children or grandchildren or great-grandchildren, that extra 175,000 will come into play. If he wants to give it to his sister or mother or anyone else, that additional extra 175,000 will not work. That will only apply to your lineal descendants. Okay, so your sons, grandsons, daughter, granddaughter, great-granddaughter, things down the line. Okay, not across. Okay, now sometimes people think that, oh, okay, I'll give my house to my children. I don't have a mortgage on it. Obviously, it won't work if it's got a mortgage, because you can't give it. But if there's no mortgage, you paid off your mortgage, you think, okay, I'm going to give my house to my children to transfer it into their name, and then so they don't have to pay tax when I die. Unfortunately, the tax office here has thought of that idea, all right, and has said, no, if you pass your house to your children within 7 years, and you die within that 7 years, that will count as part of your own estate. Okay, if that 7 years passes, then you're free. Okay, except if you give your house in name only, so you transfer it on paper legally, you transfer the title deed, but in name only, but you still live in it. You still live in that house. Okay, so you really haven't given it as a gift. You're still making it as a gift. Then the tax office says no. When you die, even if you die after 7 years, if you die after 10 years, if you die after 15 years, we'll still count this as part of your own estate because you're still living in that house. You're making use of that house. You have the benefit of that house. So really it's yours. On paper, you might have transferred it to your son or your daughter or to anyone else. But if you keep the use of it, so if you live in it still, or if you get the rent from it, say if it's rented out, then the tax office says, no, it's still yours and it'll count as part of your tax liabilities when you pass away. All right? It's a lot of, basically, it's a lot of complicated rules. So again, we can't cover everything in the time, unfortunately. So let me just go back. So in wills also, in this country, if you pass away with children under 18 years old, there is no automatic, so, in our country, it's the right that the grandparents will have the rights, that they will take the custody, the trusteeship of the children. In this country, there's no automatic right, unless you make that choice in your will, or you make another trustee document to say that I want my child, if I die, if me or my husband die, I want my child to be looked after by this person. Okay, that's the only time where the court will take account of what your the trusteeship of the children. There's no automatic right for the aunt to take trusteeship. There's no automatic right for the to be Paula and whoever grandfather, grandmother. There's no automatic right, and God forbid, if there's a family dispute, one grandparent says I want the children, another grandparent says I want the children, it will go to court, because the court will have to decide, unless you've got a document which says I appoint, Mrs. Abbas to be the trustee of the children. It has to be in writing. It's normally done in a will, but it can be done outside of a will as well. All right. So that's the thing there. No, as long as it's in writing, it doesn't have to be legalized. It has to be legal, but it doesn't have to be legalized. Okay. Sorry? No, legalized is different. Legalized is if you send it to the legalization office. But legal is as long as it meets the requirements, then you're fine. It can be by specific, it cannot be. It doesn't have to be, if you know what you're writing. So that's a very, 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 very quick overview of wills. There's just one other thing that I want to mention, which are powers of attorney. Now, as I said, the second that a person loses mental capacity, they lose the right to make a will, to write a will. As I said, any previous wills will be fine. That's absolutely fine. So now in this country there is a power of attorney. So again, some of you might be familiar with the power of attorney. The kind of just that you go on holiday, you give it to your friends to look after your property, or to look after your bank account or something like that. If you make an ordinary power of attorney, again, as soon as you lose mental capacity, that becomes void. Okay, that lapses. But there are now two types of powers of attorney that a person can make, again, whilst they have capacity to make that attorney. One which deals with their property and financial affairs, and one which deals with their health and care. Okay. Now these two, for them to be legal, they have to be registered with a special court called the Court of Protection, and it takes, I don't know, about 9 weeks or so for that court act to register it. Now, once that's registered, it means that once it's registered, the person involved, as I said, there's two. There's finances and there's care. So God forbid, if you get to the position that you can't make decisions about your care anymore, then the person that you've appointed as your attorney can make decisions about your care, about what hospital you're in, about the life-saving treatment that you should be receiving, about the medicine, about just your plan of care. That will only come into force once you lose the capacity. So it won't come into force while you're fine and nothing's wrong with you. Okay, but once you lose mental capacity, that means that the attorney will then make decisions for you. The property and financial one, you can decide whether that attorney can work, can act as your attorney whilst you have capacity, or only when you lose capacity. Okay, so basically that, and you can limit their power. So you can say, okay, they can operate my bank account. For example, if you're, get to the stage that you can't go to the shop anymore and you can't operate your bank account anymore, you can give a power of attorney to someone to operate your account for you, but only your account. So they can't sell your property or they can't sell your items or things like that. So you can give them as much power or as little power as you want to. And there you can specify if that comes into force straight away. The financial one can come into force straight away, or it will only come into force when you lose capacity. Okay, so those are very two important things to be aware about in this country as well. Okay, but again, they have to be registered before you lose capacity, God forbid. Inshallah, no one gets to that stage here. But once you don't have the mental capacity to make that power of attorney, you've lost the right. Okay, if it's registered, you can do it now. In 10 years' time, you lose the capacity. That will still work. That power of attorney will still apply. Okay, so that's again a very brief overview of the powers of attorney that we have. They've asked me to talk about marriage. I don't really know. There's not much to say about marriage in this country, except that they've changed the law a few years ago to say that only before you used to be 16, now it's 18. Okay, so you can only get married once you're 18. As a legal marriage, obviously. Once you're registered as the legal marriage of your husband and wife, obviously any children will be the rights of both parents have rights to children. Again, there's no automatic assumption that it will be the father or the mother. God forbid if there's any problems with divorce or etc. It will just be what's the best interest of the child. Divorce laws, they've changed again now as well to say that before you have to blame your husband, you have to blame your wife if there was any problems. But now there's a new no-fault divorce which is coming into the law since last year. It's given a bit longer of the waiting time to wait, but basically you don't have to blame your husband or your wife, so it reduces the pressure on the parties. And that's, I think, pretty much it. What we can say about marriage. There's not really much else to say about marriage in this country, except that they've changed the age to 18. Okay. If there are any questions, please feel free to ask any questions. Everyone understood everything perfectly. That's brilliant.
The question I had was regarding if you own a share of a business, let's say.
Yeah.
I assume that would still be liable to inheritance tax.
Yeah. Yeah.
Okay.
Your business will count if it's your business or your part of the business. That will count as your estate.
Stocks, shares,
everything. Stock, shares, everything that you own or part of. Okay. So yeah, that will count as your estate. Correct. Anything else?
Marriage, those they have married other countries, like for example Iran, they have to
register.
In this
No. As long as they married legally abroad, as it's not just like Islamic marriage, if it's regarded as a legal marriage over anywhere, Iran, Arab, wherever it is, as if it is a civil legal marriage, then it's recognized here.
So you have to translate it.